Good afternoon, Mr. De La Garza. Could you please introduce yourself to the jury?
Sorry about that.
Uh,
Yes. My name is Henry De La Garza.
and I'd like to just have you take a minute and a half or so and give us a little of your background, where you're employed, and what you do there.
I work at the Office of the Attorney General, an agency of the state of Texas, and I am the HR Director, the Chief Employment Counsel, and the Ethics Advisor.
And how long have you held the position as HR Director?
HR Director, Interim Director, November 2nd of 2020, and then became Permanent HR Director December 1st of 2020.
How long have you worked for the Office of Attorney General?
I started in 1995 as an Assistant Attorney General 1 and worked my way up.
And what division did you start in? Have you always been in human resources?
No, I started in Habeas Corpus Division and then went to Transportation Division and then Human Resources.
How many attorneys general have you worked for at the agency?
Well, let's see. I guess it would have been Dan Morales and then John Cornyn, now Senator Cornyn, Greg Abbott, now Governor Greg Abbott, and then Ken Paxton, and then also the Provisional AG John Scott and Provisional AG Angela Colmenero.
How many years have you been working in human resources?
I started in May of 2008.
You've testified that you've been at the agency for a couple of decades. How would you describe your experience working at the Office of Attorney General?
The agency is an outstanding state agency. It's a great place to work. This is as a lawyer, it's an ideal place to practice law, whether you do civil, criminal, trial, appellate, transactional, plaintiff, defense, whatever. We have it, and as an agency, we're number one in child support enforcement. This is an agency of lawyers, of child support officers, peace officers, and a lot of hardworking employees.
And as the HR director, how many employees at the Office of Attorney General are you responsible for, enforcing agency policy and procedure?
Well, the approximately 4,000 employees that we have throughout the state of Texas. And we also handle human resources work for the State Office of Risk Management, SORM.
And just generally, what are your responsibilities as both the ethics advisor, the HR director, and the chief employment counsel?
Well, it's quite a bit. As HR director, I oversee the HR operations for our state agency, 4,000 employees throughout the state of Texas. I lead a team of 22 talented and dedicated employees. We handle all sorts of HR functions, from hiring, posting, classifications, onboarding, benefits, leave, training, development. We have a wonderful wellness program, and we also have a robust law clerk program. And as Chief Employment Counsel, I, along with the other attorney in the division, excellent Deputy Chief, we provide legal guidance to the managers and supervisors of the agency, and we, make sure, EEO compliance, the rare EEOC charge of discrimination, and workers' compensation, and unemployment benefits. And then as ethics advisor, I provide guidance to approximately 700 lawyers of our agency, mostly on the Texas disciplinary rules of professional conduct, other ethical issues, and then I oversee the agency's fraud, waste, and abuse prevention program. I think I have it all.
I started as a law clerk at the office, and so I certainly appreciate everything that you do for the office. Outside of working in HR, do you have any other experience with employment law?
Yes, before starting in HR, I worked in the transportation division where I managed the employment law matters for TxDOT, another outstanding state agency, and handled the trials, appeals, hearings for state and federal law for all different types of employment laws. Title VII, Chapter 21 of the Labor Code, FMLA, FLSA, ADA, First Amendment retaliation, whistleblower retaliation, USERRA retaliation, workers' comp retaliation, all that.
And so you mentioned the Whistleblower Act. Have you ever taken a Whistleblower Act case to trial?
I actually have.
Okay. And does the Whistleblower Act, does that have certain requirements in order to state a claim?
It does.
And does it also provide specific remedies?
It does.
Is one of those remedies removal from office?
It is not.
And who is a proper defendant under the Texas Whistleblower Act?
The government entity.
Is an elected official a proper defendant under the Texas Whistleblower Act?
No.
Where are Whistleblower Act claims usually adjudicated?
It's a state law claim, so it would be in state district court.
Are you aware of a Whistleblower Act claim ever being litigated outside of the state district court?
Not under the Texas Whistleblower Act.
Are you aware, Mr. De La Garza, that in 2020, a group of high-level staffers made reports to law enforcement about the Attorney General?
I am.
And are you aware that some of those staffers subsequently filed a Texas Whistleblower Act lawsuit against the Office of Attorney General?
I am.
And to your knowledge, is that case still pending?
Yes, in Travis County.
You mentioned that you've worked under a number of attorneys general, and so I just want to ask you a few brief questions about how the agency works. How do most employees of the Office of Attorney General obtain their positions?
Most employees, we're talking about, just about everyone, would apply through a competitive posting, and then the hiring manager would select the best qualified candidate.
And how did the former staffers who made those complaints to law enforcement, how did they obtain their positions?
They were appointed by Attorney General Ken Paxton.
And so, and to be clear, I think you said there are about 4,000 OAG employees?
Yes, about 4,000.
And about how many are appointed?
We're talking about half of 1%, maybe 0.2% or 0.02%.
Is it your understanding, Mr. De La Garza, that the Attorney General has authority to appoint certain high-level policymakers?
Yes.
And what is that understanding based on?
Well, it's a well-established concept and tradition in the United States of political patronage. This has been affirmed in Supreme Court law, U.S. Supreme Court law, federal law, state law, that elected officials, whether you are the governor or the attorney general or the elected sheriff of a county, that you have the right to hand select people who are going to help you reach the goals and the vision that you've presented to the electorate and who voted you in.
And for those appointed officials at the Office of Attorney General, are those appointed officials still required to comply with agency policies, just like every other OAG employee?
Yes.
At this time, Your Honor, I'm going to move to admit Attorney General Exhibit 431. Council and I discussed this during the break, and I understand that there is no objection.
No objection.
Admit AG 431 into evidence.
Mr. Arroyo, could you please pull up AG 431? And could you turn to the second page, please, Mr. Arroyo? Mr. De La Garza, is Exhibit 431, do you recognize this as a copy of OAG policies and procedures?
On the screen, there's nothing on the screen.
Oh,
Hold on one moment. We'll stop the clock for a moment.
Hilton's.
Okay, so that's Amy Hilton doing the questioning. She's another one of the attorneys that's on temporary leave from the Attorney General's office. And I went back and looked at the records I had gotten from the AG's office. So during June and July, she was paid about $21,500. I mean, give or take. And so that's, I had interviewed a number of ethics experts on this question of, employees, attorneys in the AG's office taking leave and then going to defend Ken Paxton. And, all of them, thought it was problematic.
Well, and working for a law firm, right? I mean, they're working.
Yeah, because Stone and Hilton, Judd Stone and Christopher Hilton created a law firm.
And apparently she's named Hilton, but not related.
As far as I could tell,
tell.
I don't have any indications that they're not related. That they are related. I think it's just a coincidence that both of them have the last name Hilton.
Mm-hmm.
So this is their side gig right now. They're representing their boss, their
Right.
former boss,
While on temporary leave,
Right.
and all the attorneys that took temporary leave. One of them didn't have any leave time, so they didn't actually draw anything.
Who was paid the most?
Who was paid the most? I can look at my little spreadsheet here. Judd Stone.
Judd Stone.
Judd
Okay.
Stone. 37, about 38. I'd have to total it up exactly, but
That's pretty good leave money.
well, he is the Solicitor General, so he's a pretty high-ranking person
He's
in
the
that
top
office.
litigator.
Yeah, and so
Has he done any?
I
Has
have
he
not
done anything?
seen Judd Stone. Chris Hilton's the one we've been seeing. Chris Hilton is the, I believe his title is Head of General Litigation, and he's been pretty involved in, he did the press conferences, and of course you, Bud, you saw him at that hearing.
Right, at the Ethics Committee hearing where the articles of impeachment were reported out from committee and sent to the House floor. General Investigating Committee.
One thing we haven't talked about, are they about to go back? Okay, let's take a listen.
Members, return to your seats, please. Hold on one second, Amy. You start the clock again. Proceed.
Mr. De La Garza, can you see Attorney General Exhibit 431 on your screen?
Yes.
And you recognize that as a copy of the Attorney General, Office of Attorney General Policies and Procedures?
Manual? Yes.
And what is your role, if any, with respect to drafting and creating policies for the office?
Well, since May 2008, I've been pretty active in making sure that our policies are up to date, revising policies with new laws. For example, I know that we've got the new Crown Act and military performance and paid parental leave, things like that. So we make sure that we're always keeping up, and we make changes to the manual.
Do these policies provide that Office of the Attorney General employees are at-will employees?
Yes.
And can you just briefly explain what that means?
Well, the state of Texas is an at-will state since, I think, 1877 or something like that. And it just means that in Texas, you don't have a property right in their job. You can be fired for any reason. A little more? This? Oh. Oh, perfect. Thank you. Thank you.
Mr. De La Garza, are members of the executive administration at-will employees?
Yes.
Does OAG have an unacceptable conduct policy?
Yes.
Mr. Arroyo, could you please flip to page 43 of Exhibit 431? At the bottom, the bait stamp should end in 535. Mr. De La Garza, is this the unacceptable conduct policy we were just talking about?
Yes.
And Mr. Arroyo, if you could just flip to the next page, please. And about halfway down on those bullet points, Mr. De La Garza, one of the things that's listed as unacceptable conduct is use of an insubordinate or unprofessional tone towards management. Do you see that?
Yes.
Is that a policy that you wrote?
Yes.
And when did you write that policy?
Based on the date that I saw, it looked like it was in 2013.
And can you explain for the jury why you included that policy in the office's Policies and Procedures handbook?
It just seems typical that most manuals for employers would include something about, conduct and what's appropriate and what's not.
What are the potential consequences for failing to comply with agency policies?
Well, it depends. We look at every situation individually. It could be corrective action, such as a counseling session, a reprimand, but if it's, depending on the situation, it could be disciplinary action, including involuntary separation.
As the Chief Employment Counsel, the Ethics Advisor, the Director of Human Resources, do you provide advice to executive management on matters on employment issues?
I do.
And do you provide advice related to the application of the policies that are contained in AG Exhibit 431?
I do.
I'd like to switch gears a little bit here, Mr. De La Garza, and talk about the ex-staffers, the former staffers that left the Office of Attorney General in 2020. Who was Jeff Mateer?
Jeff Mateer was the first Assistant Attorney General.
And how did his employment at the OAG conclude?
Jeff Mateer resigned on October 2nd, 2020.
And who succeeded him as first assistant?
Because Jeff Mateer resigned and Attorney General Ken Paxton had, a right to then select someone. And, under the Texas government code, every state agency needs to have an executive head. And at the Attorney General's office, that executive head is the first assistant. And so they pretty much manage the division day to day. And so Attorney General Paxton appointed Brent Webster, and then he began that same Monday, I believe, October 5th, 2020.
At the time that Mr. Mateer resigned, were the other former staffers still employed at Office of Attorney General?
Yes.
And so at that time, they reported to Mr. Webster, is that right?
Yes. Starting on October 5th, 2020, they would have been reporting to First Assistant Brent Webster.
And would those staffers be required to comport with OAG policies in their interactions and their work for First Assistant Webster?
Yes.
And that would be a reasonable expectation that Mr. Webster would have of them?
Yes.
Let's talk about Ryan Bangert. Do you recall what his title was?
Ryan Bangert was the Deputy First Assistant Attorney General.
And how did his employment at OAG conclude?
Mr. Bangert submitted a letter of resignation on approximately, I think it was October 28th, 2020, and then left the agency as identified in the letter on November 4th, 2020.
And what about Darren McCarty? How did his employment at OAG conclude?
Darren McCarty was the Deputy Attorney General for Civil Litigation, and Mr. McCarty submitted a letter of resignation on, I believe, October 26th, 2020, and then left the agency pursuant to the letter he left on November 4th, 2020.
And what about Blake Brickman? Do you remember his title?
Mr. Brickman was Deputy Attorney General for Policy and Strategy.
And how did his employment at the office conclude?
Mr. Brickman was involuntarily separated.
Mr. Arroyo, could you please pull up AG Exhibit 224? And Your Honor, I'm going to move to admit this exhibit. I understand from counsel during the break that there is no objection.
No objection.
The exhibit shall be, what was the number again?
AG 224.
224, admitted to evidence.
Mr. De La Garza, is this memo a memo that you drafted related to Mr. Brickman's employment with the Attorney General's office?
Yes.
And does this memo reflect advice that you provided to the office related to Mr. Brickman's continued employment and ultimate termination?
Yes, it was advice about if we wanted to write a justification, this could be a draft of a justification.
And is this justification, was this the result of an independent analysis that you made with respect to his employment at the office?
Yes.
Were you instructed by anybody to come to any conclusions regarding his employment?
No.
Could you please explain the conclusion of this memo for the jury?
I only see page 1. I'm not sure.
Your Honor, may I approach the witness, please, with a hard copy?
Yes, you may.
Thank you. Just the conclusion was that involuntary separation, and he could be allowed to resign.
Looking at the memo, at the bottom of page 1, you write that Mr. Brickman has engaged in the following misconduct as identified in the agency's unacceptable conduct policy. Do you see that?
Yes.
And you list a number of violations, is that correct?
Yes.
And is it true that in this memo, you indicate that regardless of Mr. Brickman's report to law enforcement, there are violations of agency policy that justify termination?
Yes. I mean, in many ways, it's just it was a situation of an employee with a new boss and having an insubordinate or unprofessional tone towards the new boss, and not following orders, directives of the new boss.
And based on the information that you were aware of at the time, was it your opinion that Mr. Brickman's had some job performance issues in the workplace following his report to law enforcement?
Yes.
And was part of that misconduct creating an atmosphere that was untenable for the agency?
Yes.
And can you just describe a little bit what that is? I'm looking at page 2 of your memo, talking about the working relationship being strained and inefficient. Could you describe what you were aware of at the time that you made this memo?
Yes. I mean, overall, it appeared that there were some pretty egregious violations of the, kind of the insubordinate tone of that policy that you had mentioned earlier. And the insubordinate tone, the demeanor, the language, the refusal to perform directives from the Mr. Brickman's new boss, new supervisor. Just overall, there were those issues really stood out. And then overall, just based on the, everything applicable state law, federal law, the facts presented, there was no reasonable expectation that he wanted to work for the new boss, the new first assistant, or no reasonable expectation that...
Objection. Narrative. We just asked for a question and answer, Your Honor.
Sustained.
Mr. De La Garza, you mentioned that Mr. Brickman's behavior was egregious. Did I hear that correctly?
Yes.
And is it your understanding that part of the egregious nature of his behavior was his refusal to meet with his supervisors?
Objection leading.
I'll rephrase.
Rephrase. Sustained.
Mr. De La Garza, what was egregious about Mr. Brickman's behavior?
I mean, based on the facts presented to me, that type of insubordinate tone and demeanor is pretty rare in our agency.
Who did you provide this memo to?
I believe I would have probably sent it to my boss at the time, the human resource director at the time, and probably Brent Webster, the new first assistant.
Who, to your understanding, who made the decision to terminate Mr. Brickman's employment?
It would have been, his supervisor was the first assistant.
And did you support the decision to terminate Mr. Brickman's employment?
I mean, based on the facts as presented to me and the applicable state law and federal law, especially about, political patronage, yes, there didn't seem to be a reasonable expectation that he could continue working with or for Brent Webster or continue serving as a high-level policymaker for the Attorney General.
And do you stand by the advice in this memo today?
I do.
Okay, let's talk about Mr. Ryan Vassar. Was he the Deputy Attorney General for Legal Counsel?
Yes.
And his employment at the office was terminated, is that correct?
Yes, involuntary separation, yes.
And who made that decision?
That also would have been the first assistant.
Did you support the decision to terminate his employment with the office?
Based on all the facts presented to me and the applicable state and federal law, yes, there was a variety of reasons. There was a lack of confidence in his...
Objection, Your Honor. Hearsay. The witness just testified based on information he received.
Sustained.
Mr. De La Garza, did you provide any recommendations concerning Mr. Vassar's, the involuntary separation?
Yes, I mean, as a HR director, I have to rely on information that is presented to me.
Okay, and sorry, I didn't mean to talk over you. When you were providing those recommendations, were you advised by management of some issues, some job performance issues that they were experiencing with Mr. Vassar?
Objection, hearsay, advised by management, out of court statement, Your Honor.
Your Honor, if I may, I'm asking about the facts that inform his recommendation. I'm not offering them for the truth of the matter, but rather for just the things that he was aware of at the time he made his recommendation and why he made that recommendation.
So Your Honor.
I'm going to sustain your objection. Find another way to ask the question.
Thank you, Your Honor. Did agency policy support the decision to terminate Mr. Vassar's employment with the agency?
Yes.
And was it your understanding that Mr. Vassar had violated agency policy by sharing confidential grand jury subpoenas outside of the agency?
Objection, Your Honor. I need to interrupt. This is knowledge gains through hearsay and leading.
Sustained.
Could you please describe what the violations of agency policy were that supported termination?
Well, just overall, as far as the reasons presented to me for separating him were, there's a combination of...
Objection, Your Honor. Reasons stated to me is an out-of-court statement, hearsay.
Your Honor, again, this goes to the basis for his recommendation. This is not he's not testifying as to the truth of it, but rather the information, his understanding of the information and what informed his advice to the agency.
We'll overrule your objection this time.
You can answer the question, Mr. De La Garza.
Yes, I mean, I have to rely on the facts presented to me. I mean, we have 4,000 employees. So with respect to Mr. Vassar, I had to rely on the facts presented to me on what he had done or had not done. And so as far as the overall reasons, there was a variety of reasons, a lack of confidence. There were some issues about his performance, some issues about the handling of grants or mishandling of grants. Overall, there was some insubordinate tone and demeanor, and overall, there was, my understanding, there was one last meeting to see if there was any reasonable expectation that Mr. Vassar could or wanted to work with or for his new boss,
Objection, Your Honor. I apologize for interrupting. Can we keep this question and answer? My objection is narrative.
Sustained.
Mr. De La Garza, let me ask you about that meeting. You mentioned that there was one last meeting before there was a decision made to separate Mr. Vassar from his employment at the office. Were you present at that meeting?
No.
Were you later requested to provide counsel as a result of what had happened in that meeting?
Yes,
And sorry, I'm going to stop you right there just because I want to make sure that we're keeping this question and answer. But I appreciate your testimony. When you were asked for advice, did you ultimately recommend separation?
Yes.
And do you agree with that decision today?
Yes.
Let's talk about Mr. Maxwell. Was he the director for law enforcement?
Yes.
And was his employment also terminated from the Office of Attorney General?
He was involuntarily separated yes.
And who made that decision?
First Assistant Brian Webster.
Did you advise Mr. Webster with respect to that decision to terminate Mr. Maxwell's employment from the agency?
I recommended that it could be done, that it was reasonable based on the facts presented to me.
And did you personally have prior experience with Mr. Maxwell and some violations of agency policy in the past?
Yes.
And how would you recommend, or excuse me, how would you describe your experience working with Mr. Maxwell?
I mean, I admire all that he's done, but with respect to HR issues in HR, certainly it was a developing pattern of not going to HR for guidance on some very sensitive HR matters.
And did the failure to go to HR for guidance on very sensitive matters, did that ultimately expose the agency to liability?
It could have.
And about how many instances?
Well, there was one case with a Hispanic peace officer, a female, who had been subject to sexual harassment.
Objection, Your Honor. This is knowledge gained through hearsay. Presumably, he did an interview with this woman who will not come in to testify. All of the information he gathered and he's relaying to us is hearsay.
Your Honor, I'll move on.
Sustained. Continue.
I'd like to offer what's going to be marked as AG Exhibit 1055. I understand counsel does not have an objection to this either.
No objection, Your Honor.
Admit 1055.
And Your Honor, may I approach the witness with a hard copy? Thank you. Mr. Arroyo, could you please pull up AG Exhibit 1055? Mr. De La Garza, do you recognize AG Exhibit 1055 as an email that you drafted to Brent Webster and Aaron Reitz?
Yes.
And does this memo provide your legal advice regarding the continued employment of these staff members?
Yes.
What prompted this email?
Mr. Maxwell and Mr. Penley, Mr. Maxwell and Mr. Penley had been on investigative leave, and they wanted to have a meeting to see if there was any reasonable expectation that they could work with or for Brent Webster.
And I'm sorry, Mr. De La Garza, just for the record and for clarification, when you say they wanted to have a meeting, who is they?
Well, primarily the first assistant, Brent Webster.
Thank you, and I'm sorry to interrupt. Please go on.
And there was this kind of a sort of a last ditch, let's see if there's any reasonable expectation that they could work with or for Brent Webster, the new first assistant, and whether there was any reasonable expectation that they could continue as high-level policymakers with Attorney General Ken Paxton.
And so is this email your suggestions of things to ask in those meetings?
Yes.
Why did you pick these particular questions, like, do you trust me? Do you trust the Attorney General? Are you committed to the vision? Why did those questions make it into this memo?
Well, based on the case law, Elrod v. Burns, Branty v. Finkel, and its progeny, that's what you focus on: the loyalty, trust. Can the elected official, trust the people that he's or she is chosen to support their vision, their goals?
And why would that be important to the agency?
Well, it's definitely a question about efficiency. I mean, you want the everything to move along. And if his deputies aren't, if they're not seeing eye to eye, it's going to break down, and then it eventually starts trickling down, and we start losing, efficiency, and there could be worse problems.
Mr. Arroyo, could you please pull up House Manager's Exhibit 383? And Your Honor, this is already in evidence. May I approach the witness with a hard copy? Thank you. Mr. De La Garza, do you recognize this email that was sent by Greg Simpson, your former boss, to Brent Webster copying you related to the CID division?
Yes.
And I don't want to go through this whole thing, but I just want to ask you, on the second page, could you please read aloud the last two sentences on the last page of this document?
It reads, overall, HRD has had difficulty getting CID to work with us on matters that are appropriately and exclusively within HRD's authority. Maxwell's actions have exposed the agency to potential liability.
And what does HRD and CID, what does that mean?
HRD would be the Human Resources Division, and CID would be the Criminal Investigations Division.
And the Criminal Investigations Division, that was the division that Mr. Maxwell was chief of, correct?
Yes, that's one of the primary divisions under law enforcement, under his purview.
And so does this email identify a number of issues with Mr. Maxwell's management of his division?
Yes, Mr. Simpson explained that there were some challenges that HR had faced.
Did you agree with the decision to terminate Mr. Maxwell's employment with the agency?
Yes, based on the facts presented to me and the applicable law, it seemed reasonable.
And, okay, you can set that aside. Thank you. Do you agree with that decision today, Mr. De La Garza?
I do.
And who made that decision?
That would also have been the first assistant, Brent Webster.
I'd like to talk to you about Mr. Penley. Do you recall that he was the Deputy Attorney General for Criminal Justice?
Yes.
And he was also involuntarily separated?
Yes.
Was he offered the option to resign?
Yes, he was.
And to your knowledge, before Mr. Penley was let go, did he meet with Brent Webster?
Yes.
And did he have the meeting that you suggested or that you mentioned earlier about whether there could be a reasonable expectation that Mr. Penley could work effectively with the new first assistant?
Yes, that meeting took place.
And what was your understanding about the prospect of Mr. Penley being able to effectively work with Mr. Webster following that meeting?
My understanding from that meeting, it was that there was no reasonable expectation that Mr. Penley wanted to work with or for his new boss, First Assistant Brent Webster, that he could in the future, and that he could serve as a high-level policymaker for Attorney General Ken Paxton.
Did agency policy support Mr. Penley's involuntary separation?
Yes.
How so?
Well, just based on the lack of confidence, there was some evidence of questionable decision making, just the breakdown in the working relationship. There may have also been, from what I recall, some insubordinate tone or demeanor towards Brent Webster. And so just overall, based on the applicable state and federal law and the facts presented to me, it seemed reasonable, and the policy supported that.
Was it also your understanding at the time that Mr. Penley had omitted some material information in a court filing?
Yes, that had been also presented to me as far as some, wrongdoing, whether it was misconduct.
I apologize for interrupting. This had been presented to me as hearsay, out-of-court statement. We object to hearsay.
Your Honor, this is the same ruling that you made earlier to overrule the objection. This is the facts that were presented to him that informed his advice to the agency and that was subsequently conveyed to Mr. Webster, who determined what the employment decisions would be going forward.
Your Honor, if I may.
Overruled.
You
Yes,
may continue.
I'm sorry. What was the question again? I'm sorry.
Yes, the question was whether it was, you know what, I think you answered it. Thank you, Mr. De La Garza. I will ask you a follow-up question. You said it was your understanding that facts had been presented to you that Mr. Penley had omitted material information from a court filing. Is that right?
Yes, that was the facts presented to me.
And do you know whether that constitutes a violation of the agency's policy on handling confidential and privileged information?
Yes, we have a specific policy on that.
And did you agree with Mr. Webster's decision to terminate Mr. Penley's employment?
Yes, based on the law and the facts presented to me, it was a reasonable decision.
And sitting here today, do you stand by that support, that recommendation?
I do.
Mr. Arroyo, could you please pull up AG Exhibit 120? And Your Honor, this is not in evidence, so I'm going to offer it now. I understand that counsel does not have an objection.
No objection.
Admit AG 120 into evidence.
And Your Honor, may I also approach the witness with a hard copy?
Yes, you may.
Thank you. Mr. De La Garza, do you recognize this email?
Yes.
And does this email reflect some of the legal advice that you provided to the agency, including to Mr. Webster, about the application of the Whistleblower Act?
Yes, I provided some what I considered privileged and confidential advice regarding the petition that had been filed.
Understood. Mr. De La Garza, looking at the first paragraph of this email, you write, "Here is my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection." Do you see that?
I do.
And I want to ask you about that term, high-level policymakers. Why was that important?
That is the term used in sort of the political patronage case law about that elected officials can appoint. They have to be high-level policymakers for them to be appointed.
I'm sorry, they have to be high-level policymakers to be appointed. Is that what you said? Thank you. And all of the former staffers who made reports to law enforcement, in your view, fell under the category of high-level policymakers.
Objection, leading.
Your Honor, I'm just clarifying his testimony, but I can restate.
Sustained, just restate it.
Mr. De La Garza, is it your opinion that the former staffers who made reports to law enforcement were all high-level policymakers?
They were high-level policymakers.
And could you just summarize for the jury some of the points that were important to you here that led you to your conclusion that they constitute high-level policymakers that are exempt from the Whistleblower Act?
Well, based on the list that I have here, and it was supported by case law, they required more than simple ministerial competence. They created or implemented, agency goals, policy. They controlled or exercised a role in the decision-making process as to the goals and general operating procedures of the agency. They ensured that policies which the electorate had sanctioned by electing the Attorney General were effectively implemented. They all had access to confidential documents or other materials that embody policymaking deliberations and determinations. Party affiliation was an appropriate requirement. They served as
sorry, Mr. De La Garza, if I could, I just want to stop you there. At the bullet point about party affiliation. You write here that party affiliation was an appropriate requirement for effective performance of the public office involved. Is party affiliation something that the agency would look for in the employees who apply for competitive jobs in regular postings?
No.
Mr. De La Garza, do you stand by this advice in AG Exhibit 120 today?
I do.
Thank you. You can set that aside. Mr. De La Garza, did the Office of Attorney General have legitimate, non-retaliatory reasons for terminating these staffers' employment?
In my opinion, yes.
And under the Texas Whistleblower Act, can the Office of Attorney General or any state agency terminate a whistleblower based on information or evidence that is not related to their whistleblower report?
Yes.
And do you agree that that for the agency to be effective, that high-level policymakers need to be able to collaborate effectively with the first assistant and with the Attorney General?
Yes.
Did you believe that there was any reasonable possibility that any of these former staffers could do that?
Well, Darren McCarty resigned. There could have been Ryan Bangert. I would say that there was possibly with them, but
for the ones that resigned, but for the ones that were terminated, was there a reasonable expectation that they could work with the new first assistant and with the Attorney General?
Yes. For the ones who were involuntarily separated, no, in my opinion, there was no reasonable expectation.
Did Ken Paxton ever indicate expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Do you have any knowledge that Brent Webster ever indicated expressly or implicitly that these former staffers needed to be fired because they made a report to law enforcement?
Not to my knowledge.
Did anyone at the Office of Attorney General determine what your recommendations would be with respect to the legal advice you provided for these former staffers who were involuntarily terminated?
Not to my knowledge.
Was your analysis of whether the former staffers had violated agency policy, was your analysis an independent analysis?
Yes. I mean, at times I consulted with the other lawyer, my boss, before he left.
Mr. Arroyo, could you please pull up Article of Impeachment 6? And could you turn to the next paragraph of Article 6, please, Mr. Arroyo? Mr. De La Garza, Article 6 accuses the Attorney General of terminating the employees without good cause or due process and in retaliation for reporting his illegal acts and improper conduct. Do you see that?
I do.
Is good cause required to terminate an employee in Texas?
No, it's not. But at the Attorney General's office, we ensure that there are good reasons and that it's fair.
And did good reasons and fair reasons exist for each of the former staffers that were involuntarily terminated?
In my opinion, yes.
Is due process required to terminate an employee in Texas?
No, there's no property right to our jobs since we're at will. So due process, there's no constitutional right. And but we ensure that it's fair.
So, okay, thank you. And were any of the former executive administration staffers terminated in retaliation for making a report to law enforcement?
In my opinion, no.
Thank you, Mr. De La Garza. I pass the witness, Your Honor.
Thank you. Your witness. Please state your name for the record.
Yes, Your Honor. Yes, Your Honor. Daniel Duco. Hi, Mr. De La Garza. How are you?
Fine, thank you. How are
Mr.
you?
De La Garza, you testified a moment ago that you are familiar with the Texas Whistleblower Act, correct?
Yes, I did.
And you understand that the Texas Whistleblower Act affords protection to people that go to law enforcement so they can go to law enforcement without retribution, right?
Yes.
And as part of the Texas Whistleblower Act, that protection only extends to people who still have their job.
Yes, they are, yes.
Right, so what I mean is, if you report someone to law enforcement and they still have their job and then they're retaliated against, they are protected by whistleblower, correct?
If they comply with the retaliatory, the requirements in the Texas Whistleblower Act, yes.
But if they get fired before they go to law enforcement, they're not afforded the protection of the Whistleblower Act, correct?
Right, it has to be, right.
Right, so before you go to law enforcement, you don't want to tell your boss, I'm going to law enforcement.
Objection, speculation.
Sustained.
Under the Whistleblower Act, if you tell your boss you're going to law enforcement, you get terminated, then you go to law enforcement, you're not entitled to the whistleblower protection, correct?
Objection, speculation. It's the same question, Your Honor.
Just said he knew this.
You can answer if you know.
All right, could you just repeat the question, please?
Sure. Under the whistleblower statute that you said you're familiar with, if you tell your boss, I'm about to go to law enforcement, then before you go to law enforcement, you get fired, then you go to law enforcement, you're not entitled to the protections of the whistleblower statute, are you?
I guess you could make the argument in court. I'm not sure how successful you'd be.
But you agree with my statement, correct?
Probably wouldn't be the best way to do it.
So if someone were to stand up here over and over.
Witness needs to speak up when you speak.
Oh, excuse me.
If someone were to stand up here over and over and say, why didn't you just call your boss? Before you went to law enforcement, why didn't you just call your boss? Under the Whistleblower Act, that wouldn't be a good idea, would it?
I mean, if your plan was to file a lawsuit, then yes, you shouldn't do that.
You should not go to your boss first.
If you were planning to file a lawsuit, I mean, it depends on the situation.
I'm not talking about a lawsuit. I'm talking about whistleblower protection. It would not be a good idea to call your boss first, right?
Objection, asked and answered.
Overruled.
Right?
You're asking me to speculate. I'm not sure what a plaintiff should or shouldn't do.
You don't want to answer that, do you?
I'm not here to, speculate as to what a potential plaintiff under the Whistleblower Act should do or could do.
Just so we're clear, you're not here now. A moment ago, you were okay with it, right?
Objection, Your Honor. It's argumentative.
Sustained.
All right, let's put up AG 120, please. Can you see AG 120?
Yes.
This is a document that you created, an email, right?
Yes.
And in this email, it says, here are my list of why Vassar, Maxwell, Penley, Brickman should be considered high-level policymakers who are exempt from whistleblower protection, correct?
Yes.
This is your analysis.
This was a privileged and confidential document that we are brainstorming.
I appreciate that, but I think I wrote down your words, and what you said was, this is my analysis. You still stand by that?
Sure.
And you said, I stand by that today.
Yes.
And you said to the senators here, this is the correct analysis, right?
At the time, I believed it was the correct analysis. So
This argument, this exact argument that's in this document right here was made in the court, right?
I'm not sure. I wasn't involved in that.
You're not familiar with the Court of Appeals case, Office of the Attorney General versus Blake Brickman, Mark Penley, David Maxwell, and Ryan Vassar? You're not familiar with that?
I'm familiar, but I wasn't involved. I didn't work on that appeal.
Are you familiar with the decision that came out in that appeal?
I would have to read it, and
You don't remember?
to be honest, I'm not sure if I carefully, that was not something that I needed to read.
Well, if you had read it, you would know that the Court of Appeals said all of your analysis in AG 120 was wrong.
Objection argumentative.
Right? He knows,
Overruled.
right?
It happens as lawyers, you know, we make arguments and courts don't agree with them. And so, you know, there's always going to be a winning side and a losing side. And at the time, I was just coming up with potential arguments. That's what, you know, we do.
Right, so when the senators are deciding whether or not this is a valid argument, they can disregard it because the Court of Appeals already decided it was not.
Objection, this misstates testimony and is going outside of direct. This also is talking about a document that is not in evidence, and there's been no testimony before this witness about.
Overruled.
Right?
I defer to the Senate to do the right thing.
You spent a lot of time telling us about how people were involuntarily separated. That means fired, right?
Yeah, we just like to use involuntary separation.
Okay, I just want to make sure we're on the
Yes.
same page. That means fired.
It does.
You also spent a lot of time using the phrase, based on facts presented to me, right?
Yes,
And those facts were presented to you by Brett Webster.
for the most part, yes.
Doesn't it seem like you had a Brett Webster problem?
Well, he was the new first assistant, and these employees were reporting to him.
I mean, you've heard the term garbage in, garbage out, right?
I've heard the expression.
So if Brett Webster is giving you information that's not true, then your analysis is wrong, correct?
I have to rely on the information given to me.
I appreciate that. My question is a little bit different. If Brett Webster's not telling you accurate information, then all the analysis you gave on direct examination is all incorrect.
Objection, speculation.
He knows,
Overruled.
correct?
I have to rely on the facts presented to me, and so
Is my
Yeah.
question difficult?
it's you're saying that if he presented false false information to me, and I'm using that false, yes, it could affect my analysis.
Well, let's talk about the real reason why these people got fired. Stacey, can you put the timeline up, please? I'm going to use this for demonstrative purposes, so.
Your Honor, I'm going to object. I've never seen whatever this is before. Counsel and I discussed exhibits during the break. This was not provided to me, so I would request that we get a copy of whatever this is to quickly review.
Not an exhibit, Your Honor. Simply demonstrative purposes, not going back based on dates that this witness provided on direct examination. If the dates are wrong, counsel can correct me.
Well, Your Honor, I mean, we might have an objection to whatever he's going to put on this timeline. I don't know what it is, and I don't have an opportunity to verify it, and it's being published to this jury as if it's fact. So I'm going to object to displaying this to the jury.
Your Honor, they're making evidentiary arguments. I'm not offering this into evidence. It's purely demonstrative.
Your Honor,
Hold on. Don't talk over each other. I think you can provide the counsel with what you're about to show. Yes.
Thank you. Your Honor, I might have objections as this goes along because I don't think there's any foundation that he's laid yet, at least, to ask to publish these as something that's within this witness's personal knowledge. But subject to that, I appreciate counsel providing this copy, and we can move along.
Move along.
Mr. De La Garza, on September 30th, and just before we get started, I want to point out this timeline is a...
Yes.
Stay at the microphone.
Yes. I want to point out, Mr. De La Garza, that this timeline is roughly a month and a half, less than a month and a half. Do you see that?
Yes.
And as you are familiar with the whistleblower statute as you testified in direct examination, I'm sure you're familiar with 554.004, right?
Is that, could you remind me?
Sure. It says, in an adverse action, if within 90 days of reporting to law enforcement, there's a presumption of retaliatory conduct.
There is a presumption that can be rebutted.
And so the law says, if within 90 days of reporting something to law enforcement, you're terminated or have an adverse action, we are to presume that was retaliatory, right?
There's a presumption.
So, September 30th, whistleblowers go to the FBI, right?
I'm not sure. I have no personal knowledge of what they did.
The head of HR, you don't know?
That's what I heard. That's what they presented to my boss, a letter saying that they had gone there.
Let's start over. You're the head of HR, right?
Now, yes.
You know that they went to FBI on September 30th, right?
I have received information that they did. I have no reason to disbelieve that.
You also know on October 1st, the whistleblowers notified HR and the AG Paxton of the FBI report, correct?
Yes, I believe it was the first.
The next day, Mark Penley and David Maxwell were placed on administrative leave.
That's correct.
On October 13th, David Maxwell made his formal complaint against Ken Paxton.
I'm not aware of exactly when he did. Formal complaints go to the formal complaint officer, so if you say it was the 13th. But
you spent a lot of time telling us about David Maxwell. You reviewed all the file. You're telling me you don't know when David Maxwell made his formal complaint?
I don't have personal knowledge of that because formal complaints go to the formal complaint officer. They don't go to HR.
Well, we can assume by the fact that your lawyer hasn't stood up and objected that that's the day he made his formal complaint, okay?
No reason to disbelieve that.
October 15th, Brickman, Vassar, Bangert, McCartley, and Penley all file formal complaints. You know that as well, right?
I understood that they all filed formal complaints.
October 20th, so 20 days after going to the FBI, 19 days after the whistleblowers notify of the fact that they went to the FBI, Blake Brickman was fired, right?
Yes.
Lacey Mace was fired.
Yes.
November 2nd, a month after going to the FBI, David Maxwell was fired.
Yes.
November 2nd, a month after going to the FBI, Mark Penley was fired.
Yes.
November 17th, 6 weeks after going to the FBI, Ryan Vassar is fired.
Yes.
Have you ever heard of the expression, there's no coincidences in Austin? Pass the witness.
Redirect.
Just briefly, Your Honor. Mr. De La Garza, did agency policy support the termination of Lacey Mace?
Yes.
And did you recommend that termination?
I did.
Do you stand by that recommendation today?
I do.
No further questions, Your Honor.
Are you?
No need for it.
Okay, we can excuse the witness?
Yes, Your Honor.
Yes. You may step down. Thank you.